culpable as the principal offender. That's the law. And we will not be having this problem if you people were restricting yourself to real service offenses and civilians aiding and abetting crime. We will not be having this conversation. Please listen to us. But once you veer into other issues because of other reasons, then you miss out on legitimate support. I hope you've listened to me, but I've looked at you, especially the gentlemen who are lawyers the other side. Please listen to what Ugandans are telling you. Just restrict yourself to the law and the purpose of the law. Let us go to the law now. Mr. Chairman, whereas the Supreme Court judges came to the same conclusion, all of them had different reasons. So, you see somebody will pick one reason from one judgment, then he thinks that is the Supreme Court decision. And thus, maybe at some point, we need now to sit ourselves and reconcile or harmonize the reasonings given by different judges. Because there is no single judgment which gives the same reasons. All judges came to the conclusion that it was unconstitutional, but giving different reasons. So can we go and address the reasons within the different judgment, such that we talk from the same length? Colleagues, you need to read those judgments. They are quite a number. And there is no lead judgment, except that the other one was the senior judge. Because if there was a lead judgment where all judges agree with the lead judgment, that would have been even easy. But the problem is every judge wrote his own judgment, but they concluded the same way. Now, to go back to say this is what court said, that's where I think we are having a problem. And we need to sit. I hope we get time as lawyers, read as lawyers, including the Attorney General's chambers, and we can harmonize. I hope we get some experts to give us some idea. You've invited them. And we can harmonize on that one. Because it's quite easy to do that. Second, is it third? Any number. Mr. Chairman, let us look at clause 7. C. Clause 7C. Honourable Minister, why do we have this clause anymore in our laws? 7C. Members of the High Command as of 26 January 1986, whose names are set out in Schedule 3 to the Act. You know, I don't think it's very good drafting and legislating. To legislate for individuals. It is E. Yeah, it is actually E. This is not good legislation. That we are legislating that Abdul Katuntu is a member of the High Command until he dies. Really? I think we need to... first of all, the NRA has since then metamorphosized into the UPDF. It has moved on. Medals have been given. People have retired. I think the army should move on. For example, in this particular clause, Honourable Minister, assuming one is likely to survive up to 100 years. Just imagine that you are having a 100-year-old officer to be a member by law of the High Command. It doesn't make legal sense, really, even common sense. So I think at some point, maybe this I should be talking to the UPDF, not to the minister. At some point, you need to revisit this principle. The officers have served, we've recognized them, they have retired, let them live their own lives. They don't have to be members of the army organ, top army organ by law. No. No, I think we need to revisit this. And I hope at some point you concede and we move on. Honourable Minister, look at page 15, U like Uganda. such other commanders and experts as may be co-opted by the President to advise the High Command. You see, if you are advising the High Command, then you can't be a member. I think the High Command can co-opt people to advise them, not necessarily as members, but to bring their expertise. For example, we have seen members of cabinet, but there are people who sit in cabinet and advise cabinet, not necessarily them being members of cabinet. You would find, for example, National Planning Authority boss or Secretary General of the ruling party. I don't know whether it's possible. Those who come around, they listen into cabinet and they can be advised, but not necessarily that they become now members of the High Command. You need to look at this critically, because you need the services of advice, of experts. But you can't have an expert and then you are saying he's now a member. He's coming in as an advisor. And that's the power we need to give to the President to seek advice. Mr. Chairman, there is a good innovation by the bill of cross appeal, where you can appeal to the High Court. I think it's close. Clause 57. You see, I still have a problem. When you look at 2,